SJC-11793, Commonwealth v. Dennis Dorelas.
Good morning.
Good morning, Ms. Dahlberg. Why don't you wait a second?
Of course.
Okay, thank you.
Thank you. May it please the Court, I'm Nancy Dahlberg for Dennis Dorelas, here on the interlocutory appeal of the denial of his motion to suppress photographs and videos extracted from his smartphone. The Commonwealth had indicated that it would be moving to use 4 photographs at the trial in this case, but not any video extracted, and therefore the concentration has been on the photographs. Essentially, in a nutshell, the affidavit here established that the police had probable cause to search for a limited subset of files on the cell phone. That subset did not include photographs in the pictures file. In addition, the warrant did not limit the scope of the seizure to only that data for which the police had probable cause. And it did not describe any of the data on the warrant in terms of the content that would be allowed. So it was a general warrant. The defendant argues that the motion to suppress should have been allowed, both based on the absence of probable cause and the failure of particularity.
Can I just ask you, with respect to that, let's say it was limited to various categories related to calls and to text messages. Mm-hmm. How would you say, what are you saying about content? What should the warrant have said vis-a-vis content?
The warrant didn't limit.
No, I know it didn't, but what are you saying it should have? It
should have said text messages, certainly could have limited it in terms of time, but text messages related to threats received from, Mr. LaRoche to Mr. Dorelas, or some content. It just says text messages. And all the categories are listed that way. So there's no limitation. In Riley, the court talked about the ability to reconstruct one's entire life history based on photographs in the cell phone.
I guess my question is, would Riley say you had to have, that it goes so far as to say you need to say text messages relating to threats made by X to Y?
Well,
as opposed to just text messages from whatever dates to whatever dates?
Well, it could refer, this search warrant has boilerplate language of incorporation. So to the extent that it's incorporating the application, which is incorporating the affidavit, if it's specified in there, that's certainly one way to do it. But there certainly should be thought given to what are we looking for here? That's exactly what, Riley talked about. And I attached the Wynn case to the reply brief. That case is on appeal currently, but it's a very interestingly well-reasoned case that focuses on particularity. In that particular case, the court said there was probable cause to look for photographs and video, but there was a long list of items in the warrant, and there was a failure of particularity there, and it was based on the fact that it didn't limit either the scope of seizure of the data or provide as much particularity as circumstance it allowed. Here, the police had every opportunity to focus on what they really needed. They didn't do it. And for that reason, the motion should have been allowed.
So if the warrant had said, and essentially, maybe it didn't say this exactly, but search for communications between the defendant and this other individual. All right, so you go to the phone call index, you go to the text message index, emails. I think emails are different than texts, but at least they are on my phone. And you go to anything that may have been sent back and forth or captured. Why wouldn't you be able to go to photos to see if there's something in there?
Well, actually, what the police presented to the magistrate here was information indicating that the defendant had received text messages on his telephone and telephone calls on his telephone. There was nothing about photographs.
Well, I understand that, but there is suggestion that there were communications involving threats between these two individuals. So you would say, but only specific kinds of threats can be looked for, not the threatening photographs, only the threatening text messages?
Well, no, there are two issues here. One is, what are you looking for and where are you looking for it? Just traditional probable cause analysis. Looking for evidence of text messages and telephone calls.
Communications.
Well, no, they didn't say communications. You know, I think Riley, I do just want to read something that Justice Alito said. He really put the Riley finding very succinctly. Many cell phones now in use are capable of storing and accessing a quantity of information, some highly personal, that no person would ever have had on his person in hard copy form. This calls for a new balancing of law enforcement and privacy interests. The court strikes this balance in favor of privacy interests with respect to all cell phones. To say that the police, based on evidence of telephone call threats and text message threats, can go into the entire cell phone is really contra Riley.
I can go through the entire file cabinet, presumably looking for letters.
Well, they don't. It's a lot bigger than a file cabinet, Your Honor.
Oh, it's lots of file cabinets. So I have lots of file cabinets in my house. There's evidence that there have been threatening communications back and forth. They get a warrant to search my files for communications, evidence of communications. There are lots of files.
Well, I think, you know, as Riley discussed, there are many, many thousands of files. Going into someone's cell phone is more intrusive than going into someone's entire home.
Mine would be more boring, but that's okay.
Most of us probably would.
Conversely, though,
yes.
I mean, if the affidavit said that there was information from witnesses that he'd gotten threats through communications on his cell phone, you would probably
Just using the word
just word communications. Here, I understand that the words text message and calls were made. So I understand that I'm asking this hypothetically. But I mean, what would happen if it were communications instead? Then you could have a much broader sweep.
Well, I think if the police would have to provide information to the magistrate to indicate the kinds of communications that they, could ostensibly
Let's say that
be
they
made.
didn't know. Somebody was just using the cell phone. You don't really know. Okay, so you say calls and other communications. I mean, you don't know if somebody's looking at a text. You don't know if somebody's looking at an email. You don't know if somebody's looking at something on Safari.
I think like every
Instagram or.
I'm sorry.
Go ahead.
Like every probable cause particularity analysis, you're trying to be, as this court has said, as limited as you can in the circumstances. Circumstances here are all the information they have is telephone calls and text messages. So that's the universe that they're talking about. So what can be limited here? Well, we know that the police can limit their search without going into the photographs.
Well, what if there was an attachment to an email that was a photograph, and it was then stored in photographs?
So what happens is, based on this expert evidence at the hearing, is that photographic attachments to text messages come up automatically when you search with this device on the cell phone.
You search for text
so
messages.
They would get text messages, photographs automatically there. So that's part of the text message. There's no indication that he received any emails containing threats. So what the judge did in reaching his conclusion here was to say, well, if an email came with a photograph attachment, and if the photo was saved to the photographs file, and Mr. Dorelas then eliminated the email from his email from the phone and kept this one photograph, that's why that was his rationale for saying the inference he was drawing apparently that provided the probable cause in the affidavit. Now, that's not a common sense inference that could have been drawn by a magistrate, which, if I just may, if you look at the application for search warrant and the way it's written, it's very clear that the magistrate didn't write it. It doesn't make sense. It doesn't have commas in this particular section in particular is verbatim. All the language is verbatim. There are a few more commas. There isn't any possibility for the magistrate to have gone through each of these categories of data and decided that there was probable cause, and then they should have been included in the warrant. It really couldn't have been possible. It's extremely hard just to read. But, you know, going back to Riley just for a moment, I know the court there goes on at length to talk about the enormous privacy risks at issue here. And that's, of course, why there's great interest in cell phones. I think that the balance has shifted a little bit, but to my mind, this is a fairly conservative approach to this case. The police never made an effort, even though they sought the application, they signed the affidavit, filed the application, got the warrant, made the search all on the same day. They never tried to explain, why do we need to go into this separate database on this phone? What are we even looking for? They just used a template, and I don't think in this, you know, in 2015, given the way cell phones are used and the case law has developed, that police departments
First of all, this
be
was,
allowed to do
this was 2011.
Oh, that was. We're in 2015.
I'm going to go back to Justice Lang's question. Let's just say that the evidence wasn't what the brother said or the friend, but simply that somebody told the police that the defendant/victim told me that he'd been getting threats on his cell phone. Period. Threats on his cell phone.
That's sort of what it says. It says telephone threats on his cell phone, but...
It does say there are telephone threats, but in the context of these telephone calls and text messages, I think
but
one
I'm
other person said telephone threats.
Cutting out the calls and the text messages, just threats via cell phone. Does that mean you could... How would you limit that?
Well, as the court is aware, there are different approaches towards limiting cell phone searches. This court has taken, certain approaches, and they're sort of being developed. Some of the federal courts want to have a methodology, a protocol laid out as to how it's not going to be too invasive. So the jurisprudence is developing on a case-by-case basis. In this particular case...
Oh, I know it's not this case.
I understand. So in that case, it may be that something else is called for. It may be that it has to be a protocol. In this particular case, and I don't want to go back here, but it presents a situation where it makes a lot of sense to follow the model of, we have all these different databases, we can search in this fashion, and so we're going to limit it in this way. It's a moving target. We all appreciate it. And the technology is going to develop. But meanwhile, many, at least, of the police departments not appreciating that they, because they don't, maybe it's not easy to do or they don't know how to do it, they're just going to search the whole thing. Riley's made that very clear. This court has made that very clear, and I think this is an opportunity to, for one approach. In this particular case, it would have worked.
But they got a warrant here.
They did get a warrant.
That's number one.
It's too bad that it wasn't sufficient.
For the inclusion of a category of records, what is the standard? Are you saying that there must be probable cause to believe that there will be evidence in that particular category?
Yes.
So when in a drug case, when you ask for drugs and drug paraphernalia and records indicating residence, each of those categories get knocked out unless you can show probable cause for each?
Well,
I mean, generally in a drug case, you give the usual...
We're talking, okay, well, the way that the cell phone is organized, and where photographs in this situation, the photographs we're talking about are all
I know.
the pictures.
I guess the question is,
what
is the standard that in order for any category in any search warrant to be justified, you must have probable cause to believe that evidence will be found in that category? Or is it something, as it might reasonably be found once you have probable cause to believe that you can go into the
I
cell
think we're
phone.
talking about the traditional rule here, probable cause, that, you know, you have to have a substantial basis to believe that the items are related to the crime being investigated, and they'll be in the place that you think,
Okay, so is
no,
it,
you've said.
so it's a substantial basis test as opposed to
Yes.
probable cause test?
Well, a substantial basis to believe. The magistrate has to have a substantial basis to believe that there's that's sort of the definition, the traditional definition of probable cause. We're just applying it here to a cell phone.
Well, but I mean, it matters in that here, the judge found, he may not have found that there was probable cause to believe that he may have taken a telephone connected to a text and stored it in his photo file, but he said that might have happened. And is that it? I mean, so...
Cell
Can I
phone
just
connected to
clarify?
an email, I think is what he
What he
said.
actually said is, and let me, you know, it took
Photograph.
me a few times reading it. If you get a photo attached to an email, you save the photograph to your pictures file. You delete the email.
Right.
You would only see that picture in your pictures file. Text messages, even once deleted, continue to be highly searchable and with their photographic attachment. So text messages with photographs were going to be found. That's not the issue.
Unless
Is
they've
there
been
any-
written over.
Yes, which wasn't considered.
Is there any kind of a footprint on a photo that's been saved to the pictures file in the manner that you've just described that would identify it as a photograph that's been saved from because it was an attachment versus a photograph that was taken on the camera, on the cell phone itself?
I don't know what I know was in that transcript, and I don't know, I'm sorry.
Can I ask you just one other question? Is that
course.
okay? The question is, the photos that are at issue here, which if they're in here, I haven't seen
I
them.
don't have them actually, they were described.
So I take it that, well, they're not, nobody's saying they're part of a threat. This is a photo of him with the gun and the
Yes.
green jacket.
Yes.
So are you making any argument about, this sort of goes to the protocol point, that this is outside the scope anyway of the search because it has nothing to do with threats? Do you know what I'm trying to say?
Yes, that's true as well, but
That's not the argument you're making, though. This really goes to the search warrant itself.
yes.
So how,
Because if they're allowed to see the photographs, it would be plain view.
But,
Yes.
yes, but we've had this inadvertent discovery
Yes,
comes up
yes,
in
no,
preventive
and certainly in
medicine and
preventive, yeah.
stuff. Right.
And that's a hot issue, obviously, in, Professor Kerr and everybody else talking about these problems, right? Yeah.
so how is a law enforcement officer and a clerk magistrate supposed to be sophisticated enough to understand all the current today, as opposed to next month's, search engines? I mean, can't people just speak in English? Communications, threats?
No, I think it's
do we have to, how technical do these warrants have to be?
Well, I did see a warrant recently which really laid out, if the police, so the development of cell phones, certainly in my lifetime, is shocking to me. But if police want to go into a cell phone that, the Supreme Court and this court has described as containing a person's highly personal entire life.
But we have probable cause to believe that there's evidence of criminal activity in
Right. They can't go into the whole thing willy-nilly. They're going to have to, whether this court decides it's some kind of protocol, or in this particular case, which, is relatively straightforward in terms of categories, and the Wynn case talks about that, and I do commend it. They're going to have to protect anyone's privacy and to reach the balance that Riley talks about, you're going to have to become more sophisticated.
Well, but sophisticated people can keep their stuff in lots of places within this box. I mean, this little screen snap thing, which my wife showed me the other day, which is very cool. But I would never have known that. Screen snap.
Well, I
saved in
certainly
your
didn't
photo.
until the Commonwealth attached to their brief. But yeah.
So I'm just saying how we know, oh, that's possible. So maybe someone took photos. So So can't we search anywhere to see
No,
where this
I
stuff is hidden and stored?
think, as Riley says, you can't just search anywhere. You have to have probable cause, and you have to adhere to the constitutional requirements of particularity. Now, which of these, elements gets emphasized more as a jurisprudence goes, I leave to the court.
So a prospective defendant is a photographer for National Geographic. He owns a boxcar full of photographs, and they're looking for a particular photograph, and they know that it's in the boxcar. They can't go looking through all the photographs until they come across the one they want?
Well, so, there are different approaches towards this, but at the very least, they'd have to say this. They'd have to have a reason to think that it was there was a substantial basis to think that there was an item related to a crime would be there, right? Yeah. And in terms of the protocol for looking through photographs, I am not an expert, but just the way the court talked about it in, Preventive Medical Associates or in McDermott, there are ways to limit the search. You can't go through willy-nilly, and in this case, actually, the police just decided all on the same day, okay, let's look here, here, and here. And in fact, they looked for videos even though videos weren't in the warrant. So the evidence of their attentiveness to any of this is lacking.
All right, thank you.
Thank you.
Could have been a video thread.
Good morning. May it please the court. Jacksonini for the Commonwealth. Asking you to affirm Judge Brady's denial of the motion to suppress the 4 photos found on the cell phone. There's several good questions and points already made by the court. Certainly, if you're looking for a photo and it might be in a boxcar, you can search the entire boxcar. If you're looking for a photo or a record and it might be in someone's house, you can search the entire house, anywhere in the house it might be. This is horribly intrusive of people's privacy. But if you have a search warrant and there's probable cause, that's when the government can intrude, when a magistrate has found there's probable cause, and you can then invade someone's privacy.
But that you're looking for something particular in the example that you gave. You're looking for a photograph. Here, it's not so clear what they're looking for. When they say evidence of a threat, how is that specific enough to direct the searchers in what they're going to look at? It's not the same thing.
Well, I think if you read the affidavit, that it's clear there is a shootout on a street, and there are apparently 2 individuals involved, and they were shooting at each other. One of them is described wearing a green jacket. He goes back toward 86 Pierce Street, supposedly, presumably his residence. The gun is taken upstairs by his friend. So what are they looking for? If you read the affidavit and the warrant with some common sense, there's actually 4 categories of evidence they can look for, not just threats. The threats are based on debts, so they can look for evidence of debts. They can also look for the identity of the person who's making the threats, as well as the identity of the people who engaged in the shootout. And McDermott says just because the identity of the person is already known doesn't mean you can't look for more evidence of identity to confirm the identity. They can also look for evidence of firearm access, usage, knowledge, and possession by both of the people, or maybe even more people. So it may be that the 2 people engaged in the shootout, there could be more people out there engaged in this
Is there anything in the affidavit that would suggest, is there anything in the affidavit that suggests that on that cell phone there's going to be evidence about the firearms, there's going to be evidence about, I guess I just don't.
Well, so they're looking for evidence of a crime.
I see this theoretical thing, but the substance of the affidavit.
Well, in Valerio, the affidavit is incorporated by reference. It's explicitly incorporated by reference on the face of the search warrant, and the Valerio case says that's appropriate. And I think what you do is you draw inferences and apply your common sense and say, okay, what evidence does this support a search for? What do we have probable cause, and what can we look for? So there was sort of a myopic litigation of a motion to suppress, and there's a little bit of a trap, and the judge and the Commonwealth, frankly, fell into it. And the trap is, you can only look for threats. That's not really true. The warrant is broader than that, and the photos they found are evidence of identity and access to firearms, and specifically the green jacket.
Excuse
so
me,
I
Mr.
think if the
Zanini.
wa-
Mr.
yes.
Zanini, I want to stop you right there because I'm looking at what the affidavit says, and I don't think it leads you to a warrant that would be quite that broad. It says, I have probable cause to believe Mr. Dorelas' cell phone contains valuable, whatever that is, information that will link the victim, suspect, and the suspect victim, meaning the other party. So you're
Yes.
not looking for all of the things, that doesn't give you probable cause to look for all of the things that you just described. This is
Well-
a very limited inquiry here.
Right, and I would make two suggestions there. What he says in that paragraph, which is paragraph 11 of the warrant affidavit, at the end is link the victim, suspect, and suspect victim to the crime. The crime here is the shootout in the street. It's not a threat. So they're not looking for evidence of the crime of threats. They're looking for evidence linking these people in the shootout on the street. So it is fairly broad. And even if the police officer, because before that the officer says, well, I think there's evidence of threats on here. Sure. But his subjective sort of thinking, here's what I got probable cause for, that's not the universe of probable cause that the warrant establishes and that the magistrate issued a search warrant for. Now, in the McDermott case, and I think this
An
goes...
argument that was made below?
The one you're making right
No,
now?
but of course you can affirm the judge's judgment on any alternate basis which is available to this court. That's well-established law.
But you're basically asking us to act as if there were a paragraph that said, in my experience, those who have firearms will take photos of themselves with firearms.
Well, I think that's actually a reasonable inference, and there's nothing wrong with drawing the inference. So I agree the warrant
Think
certainly...
that's a reasonable inference, that people that with firearms take photos of themselves with firearms?
Sure. People take pictures of themselves with their cats and dogs. People take pictures of their new cars. People take pictures of their jewelry. They share it with all their friends. They send it out by Snapchat, email, text, and they share all of this stuff. People take pictures of themselves. They're called selfies. So there's nothing wrong with drawing the common sense inference that people take pictures of their various possessions and valuables and things they enjoy and things they like, and they even share those with others.
Well, common sense inferences and speculation tend to run into each other.
Well, I agree. There are limits there. And as Justice Gantz points out, it would be highly preferable if the officer had said, you know, in my knowledge, training, and experience, we've executed warrants on phones, and guess what? We find lots of pictures of people with their guns holding them up. I could probably go through some of the reported cases from this court and find a few of those cases here or in the appeals court where that evidence has been introduced. But I don't think it's an unreasonable inference to say if somebody goes to the trouble to go out and get themselves a firearm and go out on the street and use it, that they might have taken a picture of themselves in it. In
And I
fact, on
suppose
page-
that's one reason why cell phones contain so much more information than people ever conceived of possessing 20 years ago.
I mean, they do contain a lot of information, but if you took a picture of yourself out with a gun and hung it on your wall in your house, and we got a search warrant to search your house, there's the picture hanging on your wall.
That's in plain view. So, I mean, I guess let's...
No. We could get a warrant to go search for evidence of you who just engaged in a shootout, and that evidence would include your access, knowledge, and use of firearms. I don't need to specify I'm looking for a picture of you with a firearm.
No, but let's assume that the warrant seeks correspondence or seeks communications. Let's imagine it's 1950, and we don't have any of this stuff, and you learn that there were threats and they were communicated in writing, and you get a warrant that says, I'm looking for threats. Now, there could have been a photograph, a Polaroid attached to that. Do you get to look, and let's assume during the course of that search you see a file cabinet and you also see a photo album. Do you get to search the photo album as part of this, within the scope of that overall search?
Right. So as to the filing cabinet, you certainly get to look in the filing cabinet, in the kitchen drawer, and the desk drawer, and who knows where else you get to look. And in the McDermott case, the court said, you know, if you're looking for records of someone's access to firearms or mental health or other issues, you even get to seize the computer, even though the search warrant doesn't say computer, because the records can be in the computer. Now, can you look in a photo album? Well, since threats can be conveyed by photograph or photographically, and there's a storage place there for photos, and those might be threats, the answer is yeah, I get to look there. And again, the computer is a repository of data, and the cell phone is a repository of data. And we don't know exactly how it's set up and how it's organized and where people are storing their forms of data inside that filing cabinet. So you get to at least make a cursory examination of the entire data in there in order to look for the specific data that is relevant and authorized by your search. So in the McDermott case, they were able to do it with a mechanism that they applied where the court said it's not necessary ahead of time. We're not going to prescribe how you do it. And what the police did was come up with some search terms.
Why shouldn't they do that with cell phones? I mean,
well, the problem with McDermott is that they probably did an under-inclusive search. So it's like when I do legal research and I use a search term, I may not find the case on point because I didn't figure out the right term. And it's not a question, you know, the reason you don't have to do it is the same way if I go in your house to look for the records in your house, the documents in your house, I don't have to have the magistrate say to me, you can only look in the files that are marked, you know, tax fraud records. You can also look in the files that say not tax fraud records because people are going to try to disguise them.
The search in McDermott was okay precisely because the police had done all of these things to limit the scope of the search. But that's totally different from what you have here. You have basically a search of the entire cell phone based on the warrant. I mean, what couldn't they look at on this cell phone?
Well, again, we'd have to look at this particular cell phone and see what was on that cell phone and what applications were on that cell phone in order to know.
But don't you think that the warrant has to give some direction to the police before they even open up the phone? That's the problem here.
Well, well, first of all, you can't always know what's on there before you open it up in terms of applications and so-called file folders and places to store information. So if what you're saying is the police need to get a warrant to open the phone and look at it and then do part of a search and then run back and get another warrant and then do part of a search and run back and get another warrant, you could set up that regime. It seems excessive. And it does tell them what to look for. It says go look for evidence of the crime. But you can look anywhere that evidence might be. You can't say you can look for evidence of the crime, but not in that file where it might be, only in the other file where it might be. And we're using files as a descriptive terminology. What we have here is data, which is ones and zeros, which is bits and bytes, which can be stored almost anywhere on that phone. And
so there are no limits.
Well, I think the limits, again, the limits are the traditional limits. The traditional limits are you can look for the evidence of the crime. You may see something else while you're looking because you're looking in a place where the evidence could be. And indeed, like in the boxcar of photos, you might see lots of photos that aren't evidence of the crime, and you might even go through the whole boxcar, and you didn't find the photo you were looking for because it's in the garage. And then when you go in the garage and look through the garage, you see all sorts of other interesting things, none of which are evidence of a crime, some of which might be highly private and confidential. But the only reason you're in the garage looking is because you got the warrant, and the warrant said you can go look for the evidence of that crime. You're going to see all sorts of other things, none of which you're ever going to share with the public or disclose to the public.
Well, on your theory, you can certainly use them to charge other crimes, correct?
It's quite possible, but you don't have to reach that in this case. And in fact, you know, if you think for a second about the preventive medicine case, somebody saw or theoretically saw or was likely to see attorney-client privileged information. The court authorized it, the magistrate authorized it, somebody other than the attorney and the client saw it, read it, and reviewed it. That's highly invasive. But there was no irreparable harm there. There was protection in place. So during the course of executing warrants, yes, the government sees all sorts of information that otherwise would not be made public.
So what is your view as to whether there should be some protocol employed, that whether we should revisit McDermott's statement that there is no need for any protocol before you search a computer?
Well, I don't think that's a good idea partly for the reasons set forth in McDermott, which specifically, I believe it's at page 775. The judge or the officer issuing the warrant does not have the technical expertise to assess the propriety of a particular forensic analysis. A cursory exam of the files is permissible. And technology is so rapidly, developing here, I don't think you can predict how the files are going to be stored, how the data will be stored tomorrow or a week from tomorrow, or how we're going to be able to go look for and get that data. It's impossible to know.
Not because it's going to be automatically encrypted, so.
But the court solved that in Gelfgat.
If you're looking for evidence of this crime, and you're looking through emails, and you have an idea as to who the players are and who the victim is, and you can see, you're looking, I suppose, presumably initially anyway, for information or for emails between the players and the victim. Supposing you come across an email that's between the son of the subject of the search warrant and his boyfriend or girlfriend. Can you read that email?
Well, so read imports, I guess, a detailed examination of the contents.
Yeah. Can you go beyond? Can you go beyond the information as to who it's between when you have no reason to believe that those people are participants in the crime?
I mean, I would suggest not if you know that those are clearly identifiable people who can't have anything to do with your investigation. But people do use pseudonyms. People do use, false names. And so there's times when, you're going to have to look a little closer at that particular communication. And there's times when it's going to be obvious. It's his dentist or his son or someone else. I don't need to look at it.
I'm trying to figure out whether there's any limitation on the scope of the search that you would accept. For instance, I assume for a smartphone which gets internet that one could arguably search whatever on the internet they searched for, identify whether they went to a porn site or whatever else. Would that be within the scope of a search, say in this case, where they're looking for communications?
Well, so if you're only looking for communications, the question is, can you go to the Safari? Someone mentioned Safari, so that's one search
look through
engine
GPS.
that's
I don't know
out
what
there.
else is there, but I assume you can
Firefox,
find location
Mozilla.
data.
How many different search engines are there, right? And I think the problem is if you're looking at something that looks like a search engine for the internet, first of all, it might not be. And second of all, if I'm looking for communications and I have something called Facebook, which is old technology for the teenagers, but new technology for the rest of us, the way you access Facebook and communicate and post messages and send messages is through your internet search engine. So the answer there is if you're looking for communications, you're looking at Facebook, you're going onto the internet search engine. But maybe that's why we shouldn't try to, confine too narrowly the way this is happening because of the technology that's developing. Unless the court has further questions.
Thank you.
Thank you.
We've got Rodriguez versus City of Somerville, as far as I know.
We have one more. Number 18 or 19, I forgot.